Hi, folks. My name is Killian Garvey. I'm a planning barrister at King's Chambers. Thank you so much for joining me. This is a webinar which is to discuss the proposed changes to the National Planning Policy Framework. To begin with, extending my sincere gratitude that so many of you have elected to join me. It means an awful lot, so thank you for that. I'm going to try and make this webinar as interactive as I can, so please do use the chat function to provide any questions or comments as we go, and I will endeavour to answer as many as I can. I'm not going to be coming at this with an angle as to whether these proposed changes to the NPPF are a good or bad thing. It's not really from my place to say that. I'm just going to be analysing them objectively to say, well, what are the actual implications of what this will mean on a day-to-day basis, trying to deal with planning applications. And I'm going to go through the NPPF sort of in order, but here are the big headlines as I see it. The first one is that these changes row back an awful lot of the changes that were introduced in the December 2023 iteration of the National Planning Policy Framework. So a lot of the changes that were brought in are essentially being deleted. There is some clarifications to certain policies or sort of tinkering with wording, much of which isn't going to make a huge difference in a practical perspective, but it provides elements of clarity. There's a little bit more focusing on strategic policies in terms of neighbouring authorities having to work together. The uplift in housing numbers has been removed for certain city centres, and we've got a new planning designation called Grey Belt, which is a designation that works in the Green Belt, which we will come to. Those are the big changes as I see them. So, first point, in the contents, you'll see that there's two changes. I'm not going to focus in on every single change because it would take too long, but I'm just going to hit the big ones. We see that the word beautiful has been deleted here. There's a lot of deletions to the word beautiful throughout this new version of the NPPF, which is, I should say, is out for consultation now. The word beautiful still remains in the NPPF. It's not entirely deleted, but there's a lot of deletions to it. And we've also got a new test in respect to viability in respect to Greenbelt land. Okay, the next point, we see that there's a deletion here at the bottom in respect to the written ministerial statement on first homes, which when I first started going through it, I thought, oh, maybe they've deleted that. But we'll see later on, actually, that remains. The ministerial statement remains in later parts. I'm not quite sure why they've deleted it there. And again, they've deleted the word sufficient. It provides a framework. So the National Planning Policy Framework provides a framework within which locally prepared plans can provide for housing as opposed to sufficient housing. That's, again, what I was coming back to in terms of the tinkering and probably inconsequential changes. And a lot of them I'm not going to focus on. This just provides a good example of that. I can't see how that's going to make any weight of difference in practical terms. It's a clarification, it's tinkering with the wording, but it doesn't actually have any real effect. We then get to changes to the tilted planning balance. Someone's asked, have they forgotten to delete beautiful? I couldn't tell you, but it seems like unlikely that that's the case. So back to the tilted balance and the changes that are being made. I think that this change, I said it's not really my role to have an agenda as to whether these changes are positive, but for me as a lawyer, clarity is always my preference, that we know what these policies do and that they function. And I think that this change that's being proposed is a positive one insofar as it will provide an element of clarity. Because at the moment, as current national policies written, there are essentially two ways into the tilted balance if you've got a housing scheme. The first is demonstrating that the council don't have a 5-year housing land supply. The second way, that's the most traditional and reliable way, but the second way is to show that the most important policies for determining the application are out of date. There's this point of no relevant development plan policies. In reality, almost never does that apply in practical terms, because when is it going to be the case that there are literally no relevant policies on a housing site? Unless you're York, who don't really have a development plan, there will almost always be some policy in the development plan which you can say is relevant. So that trigger is almost never actually of use. It's trying to argue that the most important policies that determine the application are out of date. And the way the law currently works is you have to get together what's called your basket. This is derived from case law. You get your basket of the most important policies, and then you collectively judge whether that basket is out of date. Problem with that is, it creates a huge amount of uncertainty. One, what are the policies that go into the basket? And two, whether collectively they're out of date. Because almost inevitably, if you've got a housing site and you've got some landscape, which is normally always inevitable, you'll have a bit of landscape harm, and you're outside of a settlement boundary. So you've got policies which are strategic, relating to land, which is your policy saying don't go outside of a settlement boundary, and then you've got your landscape policy. Now, you might be able to say that the policy that relates to your settlement boundary is out of date because these settlement boundaries were drafted pre-2012, they weren't accounting for housing needs. So you'd be able to show some policies out of date, but the landscape policy, rarely will that be out of date because it's normally hard to get a landscape policy that's drafted so inconsistently to the NPPF. So then you're left with that position of saying, well, some are out of date, some aren't out of date. Leave it to the decision maker. And it's anyone's guess what the inspector might do in those circumstances. So it provides quite a lot of uncertainty. And again, for me, as the lawyer, I quite like to be able to give clients advice as to what I think the likely outcome will be, and rather than just saying, who knows? And this does provide some more clarity, because rather than having to go through that basket exercise and judging whether the basket collectively is out of date, we now have a new trigger, which is that the policies for the supply of land. And footnote 8 tells us what those policies are. So it means that will provide a lot more certainty as to what policies we're actually directing our attention to decide whether they're out of date. Someone said, is there a legal definition for out of date? It's a planning judgment. If the council don't have a 5-year housing land supply, it's out of date. That's by virtue of what will be now footnote 9. That's an automatic trigger that the policies are out of date. But if the council do have a 5-year housing land supply, or you're dealing with a non-housing site, the policies can still be out of date. Normally you're looking at whether they are inconsistent with the framework or there's been a change on the ground. So, for example, if you've got an employment site, development plan it was adopted in the context that there would have been X amount of employment land coming forward, and actually subsequently a lot of those sites have not come forward. So there's been a change on the ground. That might be able to say, well, the assumptions that underpin the development plan were wrong, and therefore those policies are out of date. So proceeding on, we've also got in the tilted balance this reference that in particular those for the location, design and development as set out in chapters 9 and 12 and for securing affordable homes. I've thought quite a bit about what does that mean, and I'm not any wiser as to what that will actually mean in practice, how we will use that. So it will take a little bit of time, whether that has any consequence at all. And I guess I don't think it's going to make a big bit of difference as to how the tilted balance works, but time will have to tell us. Kirsty Smith, how do I think the paragraph, I should say thanks so much for the questions, folks. How do I think that the proposed change to paragraph 11D applying for non-housing development? Hopefully, as I've outlined there, if you had an employment site, it would continue. And again, policy for supply of land, which set out an overall requirement to make allocations, that would still apply. Oddly, though, these sorts of policies, if you've got an employment site, well, you'd naturally be thinking, well, do we care about the housing requirement policies at all? I mean, obviously, housing and employment go hand in hand. The more housing you need, the more employment you need. So it could be said, well, if the policies for housing are out of date, that means that the plan remains out of date for an employment site. You don't even necessarily consider the employment sites. I'm Matt. Thanks for the question. Do I think that the effect of amending paragraph 11 will be somewhat muted by the lack of change to paragraph 14? Certainly when you're getting into the context of neighbourhood plans, that will be the case. That the changes to paragraph 11 won't really make a difference where the neighbourhood plan is engaged. And that's one change that was made in the December 2023 version of the NPPF, which has not been rolled back. Surprisingly, I didn't anticipate that the government would retain this level of deference to neighbourhood plans, but they have, much to my surprise. So, proceeding on, again, we see some references to beauty and placemaking being deleted, but again, it's tinkering with the wording, it's not consequential. We then get to the point about cross boundaries, and you can see that in terms of what's brought in, it said that effective strategic planning and crossing local planning authority boundaries will play a vital increasing role in how sustainable growth is delivered. And we then see paragraph 27, which talks about collaboration and strategic policy making. Authorities should make sure that the plan policies are consistent with those of other bodies where strategic relationship exists on these matters. So there is an attempt here to try and ensure that local planning authorities should start actually working together and looking at cross-boundary issues and looking at I think there's a big focus here on real infrastructure, because you can see hospitals, universities, major schools, and we'll see later policies that deal with data centres. I think there's an attempt here to try and encourage local authorities to be working together where we're talking about large-scale infrastructure and to try and align themselves. How that's going to be enforced, it's not immediately obvious. The ministerial statement where the minister introduced these changes does talk about getting more involved and taking more direct involvement, but whether that actually transpires, we'll have to see. But certainly in a policy context, it doesn't appear to be a mechanism to actually enforce this change. And again, paragraph 28, plans coming forward at different times. Again, an attempt to try and encourage local authorities to have more cross-boundary interaction with one another. The next change that we get, I should say, all the paragraph numbers have changed. I've got to the point now, I'm almost not bothering learning the paragraph numbers because they've changed so frequently. I used to be able to, with the 2012 version, I used to be able to quote almost every paragraph. I'm not sure I'm going to learn that skill anymore. The next point that we get to, skipping ahead, so delivering a sufficient supply of homes. So there's the standard method. There's been some changes to the standard method behind the scenes, which will make a difference to how these policies operate. So the standard method, there's now, the government want to deliver 1.5 million homes within this current parliament. So to facilitate that, they have increased nationally the standard method. So the consequence of that is now that the standard method nationally results in an annual figure for this year of 371,000 homes needing to be delivered, which is an increase of 66,000 homes from the previous standard method. This language here, which is to talk about strategic policies, it's removed the option for local planning authorities to try and suggest that the standard method shouldn't apply, because the current version of the NPPF talks about the outcome of the standard method as an advisory starting point for establishing a housing requirement, and there may be exceptional circumstances where you can justify a lower figure. That's been removed, which would rather suggest that now local planning authorities ought to be adopting the standard method in national planning guidance. You can see here that there's been a removal of the uplift for certain cities, which does make quite a substantial difference. Birmingham, for example, they are now not affected, so their housing requirement has been significantly reduced as a consequence of this change. Well, it will be significantly reduced, assuming this is adopted. We then get the changes in respect to affordable housing. This is quite a big one, actually, I think. So you can see that the exception to affordable housing, that the 10% requirement, has been removed. So it appears to be a greater focus on affordable housing, which we see elsewhere as we look forward. You can see some questions have come in. Paragraph 66 removes 10%. That's quite right. Whether we see changes to this, this struck me as quite curious because they've put in an A here, which I didn't quite get why if they're just proposing to remove this. But it might be that PPG is changed to clarify this, because I confess I was surprised by this change. I didn't quite get why they were removing it. But there we go. Seb said, with this increased housing target, will we see many local authorities below their 5-year supply target, and will this rise in speculative applications? So, well, I mean, inevitably, if you increase the standard method, you increase the requirement that local authorities are required to demonstrate it. As a consequence, it's almost inevitably there'll be lots of local authorities who won't be able to meet that. So, yes, it probably will result in more local authorities being unable to demonstrate a 5-year supply. And the government have also removed the provisions relating to 4-year supply, because currently some local authorities only need to demonstrate a 4-year supply. That's been removed entirely. So I suspect this will mean that a lot of local authorities will be unable to demonstrate a 5-year supply, more so than there is currently the case, which, if the government want to get more housing delivered, inevitably they're going to have to open up the taps and make it easier for developers to come forward with applications. So it seems consistent with that notion. We then, moving forward, paragraph 76 of the proposed change to the NPPF, which isn't radically different, but it's removing the 4-year supply and it's putting back in the buffer of 5% for all authorities, which was removed, or if the local authority haven't delivered for the last 3 years, it's a 20% buffer to be imposed. And you'll see there's no suggestion of a 4-year supply, which all these parts that are being deleted. So paragraph 75, that's going to be deleted. That gave a shield to local authorities. Paragraph 76, which introduced that 4-year supply, that's been entirely removed. And this is, as I indicated, a lot of rowing back of the changes that were being suggested by the government, by the previous government in the December 2023 version of the NPPF. So all that comes out. Phil, we've got a few questions. Let me deal with some of these. So Mark, the new union authorities with no new local plan in place, Somerset, will the new standard method apply to the former district areas or the new larger council area as a whole? Good question, Mark. I don't immediately know the answer to that. However, I anticipate there will be my strong instinct would be that there would be a new standard method figure for the new authority. I can't see a reason why that wouldn't be the case, actually, the more I think about it, but we'll have to see. James, a lot of removal of monitoring as local authorities to meet 5-year supply on a continual basis. Confess, I'm not sure I see that, James, that there's a removal of monitoring 5-year supply. I'm not sure that I can see those changes. More than happy to chat offline, because I'm not, confess, I didn't detect that. Phil's asked, NPPF targets supply side of planning permissions to go into 5 supply, but what about requirements on developers to deliver them, build them out? Well, you can't ever impose a requirement on someone to actually build out a planning permission. Nor is there much evidence that I've seen to suggest, this notion of land banking and lots of developers are getting their permissions and sitting on them. I've never seen any strong evidence to suggest that that's the case. It's certainly a narrative that we hear in government, and I think that was an attempt to try and place the blame as to why we have a housing crisis, place it on the house builders rather than any accountability. I think that's my read on the situation, because I've never seen, and I've asked many times, where is this evidence of land banking? And I can't see any. And indeed, it doesn't often serve developers to sit on sites. If you kind of understand how house builders work, it's not in their interest to do so. Normally they want to build out quickly. That's normally the emphasis. And when they're not building out a site, it's normally because of a viability reason or something like that, not because they genuinely think, let's sit on it and hope it increases in value. The next point, Victoria. Hi, Victoria. Where it refers to previous undersupply, will that be based on new 5-year supply figures or those enforced in the past years? I think that would be against housing delivery test, Victoria, I think. Reese, hi Reese. Is the removal of the ability of the councils to achieve 5-year supply through an annual monitoring statement, which few ever did, the point? I think so, Reese. That annual monitoring statement was a novel idea, but the reality is almost no local authorities ever took it up. And in reality, if you were so confident that you had a 5-year supply that you thought, let's go get an annual monitoring statement, it's just additional work. I didn't anticipate many authorities would actually ever go for it. So I think it's probably an acknowledgement that it's not been a particularly great idea. Andrea, to clarify, is this delivery of local plan targets or where higher standard methodology targets? Will local plans still within their plan period become out of date if the annual requirement is below that of the standard methodology? Yes, that's certainly the case. New local planning authorities won't be afforded. When you get a new local plan, you're not afforded a shield. So your plan might be out of date at the point of adoption if your plan didn't cater for the standard method. NDAF, good to see you, NDAF. I think there was a land banking some years ago, but now it's just a hangover of that. Like you say, it's just scapegoating. Yeah, that's certainly my thoughts. But at least I've never seen any evidence to support this notion of land banking. And as I said, I've done countless housing appeals and I've asked numerous times, where is this evidence? And it doesn't exist as far as I can tell. Okay, next point. I'm going to crack on, folks. I will come back to questions, don't worry. So we see here, I talked about strategic policies and this focus on infrastructure. And here we see that. So there's an attempt here to focus in on, the grammar involved here is causes me anxiety. But say for that, I am being pedantic. There's focus here on laboratories, gigafactories, data centers, digital infrastructure, freight and logistics. So we see this focus on infrastructure here, and again we see it here: new, expanded, or growth facilities and infrastructure that need to support the growth of these industries, including data centers and grid connections. So there's a lot more focus on local planning authorities having to work with each other and focus in on these infrastructure requirements. We then get, moving forward, no changes to retail. Again, deletion of the word beautiful here, but it still is in there. The word beautiful does still apply. Again, there's a focus in on early school and post-16 places, which we see a few times here. Probably more tinkering than actually changes that are going to have a big consequence. Again, coming back to infrastructure, significant weight should be placed on the importance of new, expanded, or upgraded public surface infrastructure when considering proposals for development. So hopefully you're seeing that theme coming out, that of infrastructure. We've got paragraph 27, which is talking about strategic authorities having to work together. And then we've got paragraph 85, talking about infrastructure and then significant weight needing to be put on it. Jumping forward, we see a change here in respect to highways. Highways comes up in almost every case, in every housing case, in my experience, from third parties. Rarely is it a reason for refusal from local authorities, but you can guarantee it's going to come up at some point from local residents, because their real issue oftentimes is that they're going to be sat in traffic for longer, and that's going to be a grievance to them. And no one likes to sit in traffic, so I can understand that. So the fact they've changed this policy is they've added the words "in all tested scenarios." I think that is tinkering. I don't actually think it's going to make a whit of difference, because obviously what you're doing is you're trying to demonstrate that there's not going to be a severe impact, and you present lots of scenarios and models to demonstrate that. And if they all come out and say it's not severe, then you get home and you demonstrate that there's no highways issue. So I don't think adding the words "in all tested scenarios" is going to make any difference. I'm going to jump back to questions. When I say some things like that, I sometimes think, is this where people are going to get excited and tell me off? So let's see if anyone has. Dominic, what are the implications for custom and self-build? Does the identified need for CSB trigger the tilted balance? I don't think there are big changes in respect to custom and self-build proposed by this new NPPF. You can try and say that the tilted balance ought to be engaged because the council aren't catering for sufficient amounts of self-build. Pure planning judgment. It's one of those points where it's up to the inspector what they do with that. Helen, if we approve an application to meet our fibre supply, we could condition that they must commence within 5 years. Otherwise, how are they actually meeting our fibre supply if they do not build it in 5 years? Thanks. Well, you certainly can condition them that they have to, that the permission needs to be implemented within a certain period. The reality is, though, you can never condition a mandatory requirement insofar as it wouldn't be lawful to condition someone to say, you must build out this planning permission. It's not lawful to do so, because ultimately it's within the discretion. And ultimately, The requirement is simply to implement the permission. Obviously, in law, you can implement it just by pegging out the scheme and discharging the relevant conditions. You can do that and then sit on the side. So technically, it's not really within the gift of the authority to demand someone completes a planning permission. That's just the reality of it. Jess has asked me about Regulation 19 consultation. I'm going to come to that, Jess. Good question. There are some provisions that relate to the transitional arrangements and how this new NPPF is going to function in the context of new local plans coming forward. And they've given that some thought. It's quite effective what they've just brought in. So we'll have a look at that shortly. And Luke, if a local authority cannot demonstrate a fibre supply, but the neighbourhood plan is only 1.5 years old, which is more likely to carry weight. I think paragraph 14, Matt Tompkins made that point earlier in the chat. Paragraph 14 of the NPPF remains in place. So if you're contrary to the neighbourhood plan and it's only 1.5 years old, if the requirements of paragraph 14 are met, it's likely that the neighbourhood plan conflict would prevail over the tilted balance. That's what paragraph 14 of the NPPF is seeking to achieve. So jumping back into the text, folks, we then get effective use of land. It tells us that substantial weight to the value of using suitable brownfield land within settlements for homes and other identifying use, proposals for which should be regarded as acceptable in principle. I think that's quite a good change. I say good. There's been lots and lots of talk about brownfield land for some time, but there actually hasn't been that much policy that supports it, surprisingly. It's always the case of when you actually have a brownfield site and you want to bring it forward, it actually, whilst the policy said give substantial weight to the value of using it, there was nothing to suggest brownfield land is great. This changes that, which is now brownfield land is acceptable in principle, which is, I think, quite a big change that's being suggested. Whether it actually results in more development of brownfield land, we'll have to see. There's normally huge issues with developing brownfield sites. But hopefully this will actually give some teeth to that. There's a discussion of mansard roofs. I always find the changes in respect to mansard roofs, I don't know who's drafting that, because I didn't know that there was a huge need for it, but there we go, it's still there. We then get, jumping forward, again, deletion of the word beautiful. There's focusing on the National Model Design Code is brought in, but again, much more tinkering to the wording. We then get to Greenbelt. This is where it gets exciting. So before I jump into Greenbelt discussion, let me just take a few of these questions and then we'll get into the discussion of Greenbelt where I think it gets quite fun. So Alex, what's the strength of a neighbourhood plan that there's 1 to 2 years old, but the local authority is demonstrating increasing low housing delivery within the fibre supply, only ever getting a lower year on year due to nutrient neutrality issues? Let me jump back to paragraph 14 of the NPPF, because I think that's another question about neighbourhood plans. Paragraph 14 of the NPPF, which is proposed to remain, is that if the tilted balance is engaged, this is telling you, this is assuming that where the presumption applies, so the council don't have enough housing supplied, assuming that's how you've engaged the tilted balance, tells us the adverse impact of allowing development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits. In other words, where these two criteria are met, if you're contrary to a neighbourhood plan, even if the tilted balance engaged, it's likely that warrants a refusal. Doesn't mandate it. It's likely, so it doesn't mandate the outcome, but it's essentially saying in most circumstances where you're contrary to a neighbourhood plan, irrespective of the tilted balance, you should be refused planning permission. And that's where the neighbourhood plan was part of the development plan 5 years or less. And the neighbourhood plan contains policies and allocations to meet its identified housing requirement. So provided those two are met, that neighbourhood plan is given a huge amount of weight and will likely result in a refusal on most schemes. Again, I'm surprised that that's remained in place, but there we go. Mike has asked, who decides which scenarios are tested and which aren't in respect to paragraph 113? Well, the policy talks about in all tested scenarios. So I don't think you decide which are and aren't. You've got to consider all the tested scenarios. But I suppose in terms of thinking about, which scenarios do we need to think about? I think it would be between the highway authority and the developer. The highway authority would have to say, we want to see this scenario, and it would be up to the developer to either do that, or, which is most likely the wise outcome, or they can say, we don't think that's necessary for X, Y, Z. And that would be then, if they wanted to challenge it, they could go to appeal and have that argument. Darren said there's been no changes to heritage matters. That's quite right. James, 20% buffer will currently, where an LPA significantly underdelivers against the housing delivery target, is my understanding. That's my understanding as well, which essentially goes back to the position that we were in prior to the December 2023 NPPF. Paul says you could get a completion notice technically. That's quite right. You can serve a completion notice on developers if they don't actually want to build out their scheme. Rarely did completion notices actually get served, in my experience. But technically, that's the only way which you can really force a developer to complete the scheme. What weight should we be placing on this consultation? So the law does say you are entitled to give weight to draft policies. It's a matter of your own discretion what weight you wish to afford it. Okay, let's get to the Greenbelt discussion, folks. So most of the policy doesn't change in respect to Greenbelt policy, but the changes that are brought in is it tells us that exceptional circumstances for the lease of Greenbelt land include, but are not limited to, instances where an authority cannot meet its identified need for housing. That's quite a big change, I think, because it's an acknowledgement that need can be a justification for the release of Greenbelt land, and it's an acknowledgement within the policy itself. We then get the creation of pre-developed land in sustainable locations, then consider Greybelt land. So there's almost a sequential test of sorts. And then consider Greybelt land in sustainable locations which is not already pre-developed, and only consider other sustainable Greenbelt locations. So what is Greybelt land? Because we also get a discussion later on in the policy of a new way in which development is not considered inappropriate. Because all development in the Greenbelt is assumed to be inappropriate unless you can meet one of the exceptions. And we've got a new exception, which is Greybelt land. You've got to meet various requirements, but the question is, what on earth is Greybelt land? And to answer that question, we need to go all the way down to page 74, where we get a discussion of what Greybelt land is. And it's defined as, and there's quite a lot of caveats to this. It's defined as land in the Greenbelt, comprising previously developed land and other parcels and or areas of Greenbelt land that make a limited contribution to the 5 Greenbelt purposes. So just pausing there, let's break this down. It doesn't need to be previously developed land. It can be previously developed land, but it says, and any other parcels, i.e. other to previously developed land. So it doesn't necessarily have to be previously developed land. It can be land which has a limited contribution to the 5 Greenbelt purposes. I.e., if you've got land that makes that limited contribution to the Greenbelt, that equally can be considered to be Greybelt land. Whether it makes that limited contribution, it's down to the decision maker, and it's obviously site specific. We then get, but excluding those areas or assets of particular importance listed in footnote 7 of this framework. Footnote 7 of the NPPF, that provides the sort of the knockout points, the sites that are really protected. So we've got things like heritage assets, AOMB, local green space, national park, sites of special scientific interest, flood risk. So if you have one of those sites that's affected by one of these designations, then you can't be Greybelt land. So what constitutes Greybelt land? Going back to the definition, sorry if I'm giving anyone a vertigo by flicking through so quickly. What qualifies is we can immediately rule out any site that's affected by the sort of flood risk or A1B or anything like that. All those come out by virtue of this point. But we then what qualifies as Greybelt land is anyone's guess. And I'm not being critical. I like certainty, but essentially it would be open to any developer to say, well, we don't think our site makes a particularly big contribution to the Greenbelt purposes, and therefore we think our site is Greybelt, and therefore we fall within the remit of the policy. And that's just a pure matter of planning judgment, whether you think you fall within that remit. So jumping back to the paragraph 152 on Greybelt. So it allows for the development to come forward on these Greybelt sites. And it under prescribed circumstances, for example, the local authority cannot demonstrate a 5-year supply of deliverable sites. developments able to meet the planning policy requirements set out in paragraph 155, which we see here, which is relating to if you're going to develop in the Greenbelt, you've got to meet certain requirements in terms of affordable housing. So at least 50% of your scheme is affordable housing subject to viability. And that subject to viability, we see Annex 4, a whole new annex to the NPPF, which is dealing with viability in the Greenbelt in relation to Greenbelt release. And it tells us, I'm not going to work through it because it's quite detailed, but it tells us how one approaches viability in respect to Greenbelt land. So, and that policy 155, that would apply presumably in respect to allocations in the Greenbelt as well. Well, let me go back to some of the questions. Someone's asked, could local authorities choose to map their grey belt? Technically they can, but it's the same as if a local authority decide to map what they regard to be their valued landscapes. Because a valued landscape is a non-designation, as in you don't get designated valued landscape typically in a development plan. It's normally a planning judgment on a site-by-site basis, whether you are or not a valued landscape. Some authorities have mapped out those areas they think to be valued landscape, but that doesn't carry status, so to speak. It's simply that's their view of what is and what is not grey belt if they were to do that. And then it would be up to a decision maker on appeal, for example, to say, well, we think you're wrong. We think we are grey belt. And for these reasons, and, it'd be perfectly legitimate to do that. Kathy has asked flood risk. Has that been included in footnote 7? Yes, there's no changes in respect to flood risk policy, much to, I'm sure, lots of people's grievance. Robert, I have grey belt land, but there is a 2-year-old neighbourhood plan which does not allocate it, which takes priority. I think if you're contrary to a neighbourhood plan, going back to paragraph 14 of the NPPF, it's likely that you would be refused planning permission. That's the consequence of paragraph 14 of the NPPF. Becky, the golden rules only apply to major development rights. If you're talking about the tilted balance, no, that can apply to non-major development, if that's what you're asking. Karen, sorry for mispronouncing that name, does the 50% affordable apply to grey belt too? It does. And we can see that by virtue of paragraph 152, because that's saying if you're going to get grey belt land, you've got to be able to meet the planning policy requirements set out in paragraph 155. So you've got to meet these circumstances to effectively come forward as a grey belt site. And 155 is the provision relating to 50% affordable housing. Will there be an expectation that local authority will map? Oh, that's another question about mapping it. I don't think there's an expectation, certainly. I think the previous question was, can they? And my indication was I don't see any reason why they can't do so. But there's no expectation that they have to. How much weight would you expect to give to a council's Greenbelt review in determining whether the land is grey belt? Typically, inspectors will give quite a lot of attention to Greenbelt reviews. But, sorry to be a lawyer, but it depends. If you've got a grey belt review which looks at huge swathes of land, which is not untypical, you might say, well, that might say this huge area of land contributes significantly to the 5 purposes of the green belt. And you say, well, our site is a small little dot in that huge swathe of land, and therefore, whilst the whole area might contribute, our site doesn't. So it depends on the content of the green belt review. Mike, it's unlikely that a local authority will accept that their land in the Greenbelt doesn't make a contribution. It would be an unpopular local decision, so most grey belt is likely to be decided at appeal, surely. I don't think that's a bad point, Mike. I suspect that's probably right. Do you think it's just greenfield sites that need to be demonstrated not to have a limited contribution to Greenbelt purpose, or does it apply to PDL as well? It's my understanding, good question, my understanding of how the definition of grey belt works is if you're PDL, then that would qualify as grey belt, and then it's talking about or land that makes a limited contribution to green belt purposes. That's how my natural reading of it. To be honest, I hadn't contemplated the other version, Steve. I'll have to give that some thought, but my immediate thought is if you're PDL, you can be grey belt provided you don't fall within footnote 7. But if you're not PDL, then it's land that makes a limited contribution. That's how I read it. Richard, with the changes seeking to ensure local authorities review their green belt to meet the identified needs, can you see pressure being placed similar on not green belt policies, which are similarly restrictive, like green gap policies? I just want to understand that, Richard. So with the changes seeking to ensure the local authorities review their green belt, pressure on green belt policies. I don't see that as a consequence of this policy, if I'm honest, Richard. But as ever, we'll have to wait and see. Okay, going forward then, so we've dealt with Greenbelt. No changes to heritage. The next big change we get, I think, is the actual implementation of this and the transitional arrangements. So you can see the 4-year requirement. That's all, as I said, indicated. That's gone. And then we've got some policies relating to how this is actually brought in through paragraph 226. And they've given this some thought, to their credit. And it's me being a lawyer, I like clarity, and this is clear. So essentially, it really is fact specific as to how this new NPPF is going to work for local authorities who are trying to go through an examination. If you're at examination, so when you've submitted for examination, you can continue to apply the previous version of the framework. But where that's the case, if your plan is adopted, if you're more than 200 dwellings lower than the standard method, you're expected to commence plan making in the new plan making system at the earliest opportunity to address the shortfall housing need. So if you're at examination or you've submitted for examination, they're saying, well, you can continue. But if you're more than 200 homes short of where you should be, get on with getting a new local plan quickly. If you haven't submitted for examination, you're at Regulation 19 stage. If you are more than 200 homes over, so it tells us that the emerging local housing requirement in a local plan that reaches Regulation 19 is no more than 200 dwellings below the published relevant local housing needs figure. That means those sorts of plans will be adopted against the new version of the framework. But if you're more, then you need to go away and do some homework, essentially. So they've given some real thought here as to how these transitional arrangements work. And in summary, they're very keen that this new NPPF will be applied across the board, but they're giving some tolerance and consideration to local authorities who have reached a relatively advanced stage of their local plans. But they're trying to make it that all new local plans will be examined against this new NPPF, with, as I said, some tolerance to those circumstances where that wouldn't work. And you can see that, again, further transitional arrangements. So, and just going back into first homes, as I indicated earlier, while they deleted it in the earlier section, you can still see that the minimum statement still applies. So why they deleted it earlier, I'm not sure. Maybe they're just tidying it up. But they've deleted starter homes from the definition of affordable housing and replaced it with first homes, which doesn't come as a huge surprise. Those are the changes, folks, to the National Planning Policy Framework. Let me see if I can pick up a few more questions. If the local authority has not consulted on Regulation 19 yet, will they need to revisit housing figures and NPPF, depending on whether they are within 200 units, whether the proposed annual requirement is within 200 units of the standard method figure? That dictates whether they need to work with the old NPPF or with the new NPPF. Is the 200 dwellings per annum across the plan period as a whole? It would be good question. I think it would be across the plan period as a whole, I imagine. No, I'm so sorry. It's an annual housing requirement figure. If I share my screen again. Yeah, local plans that would reach adoption with an annual housing requirement. There's more than 200 dwellings. Yes, so it's per annum. Good question. Is there any changes in respect to student accommodation? No changes that are suggested here, Billy. And as ever, we'll get changes to the planning practice guidance to align itself with the new NPPF, and it might be levels of detail like student accommodation might be mentioned in the new PPG. We'll have to wait and see, but there's certainly no changes suggested for now. Grant, good to see you, Grant. Question paragraph 14, the identified housing requirement. Could you consider how this test could be met under the various scenarios set out in the transitional arrangements? I think, unfortunately, Grant, that if the way paragraph 14 is worded, I don't think there's clever footwork that you can do to try and get past that. Ultimately, if the neighbourhood plan contains policy allocations to meet its identified housing requirement, i.e. the housing requirement that existed at the time that it was adopted, I don't think you could say, well, it doesn't do that because the housing requirement is now increased. I'm not sure that it would be within your gift to try and pursue that argument. Anna, when would you estimate the earliest time the new NPPF will be brought into force? The government have said that it will be the back end of this year. It wouldn't shock me if it's December, but I don't have an inside track on that. But just that the way the government announced it is that they indicated it would be by the end of the year. There was an earlier point where they were talking about September, but they've subsequently clarified that they're talking the end of the year. What weight is the ministerial statement on decision-making now for housing? Is the December 2023 NPPF still fully in play? December 2023 NPPF is still fully in play. My reading of the ministerial statement is it's the government saying this is what we propose to do. So whilst it is a ministerial statement in force now, given it's saying this is what we propose to do, but to my mind, it very much aligns itself with the new NPPF, and what weight you attach to the new NPPF is up to the decision maker. You can have regard to it as material consideration. As I said, what way you apply to it is down to the circumstances. Eddie, where a local plan can be prepared to meet the new... Sorry if I'm skipping over questions, folks. There's quite a lot, so I'm not deliberately trying to avoid any. Apologies if I've missed one of your questions. Eddie asks, where a local plan can be prepared to meet the new standard method without greenbelt review, can grey belt proposals be refused as inappropriate development? You can still refuse it as inappropriate development, but it would come down to have you met the requirements of paragraph 152 of the NPPF? That would be are you grey belt land insofar as you don't make that important contribution, or you previously developed land and you don't fall foul of footnote 7. But if you are grey belt land, can you meet the requirements of paragraph 152, which includes the local planning authority not having a 5-year housing land supply? The next question, Alex, as footnote 7 still refers to greenbelt, does that mean application of greenbelt where no 5-year supply can be demonstrated would be considered appropriate development of greenbelt? Wouldn't trigger the tilted balance in decision making? You still decide in flat balance. No, that's not quite right, Alex. It's a good question. So at the moment, that policy doesn't really, footnote 7 isn't proposed to change. The way that works is that for decision taking, if you're in accordance with an up-to-date development plan, get permission without delay. If that's not the case, and most local plans will have a policy on greenbelt which says unless no development unless very special circumstances. So if you've demonstrated your very special circumstances, you could technically accord with an up-to-date development plan. Because you'd say, well, the very special circumstances apply. But the way that this works is does the application of policies protect areas, provide a clear reason for refusing the development proposed? And then you go through all these various points. Just because you're in the green belt, it doesn't mean that you've necessarily got a clear reason to refuse development, because if it was demonstrated very special circumstances exist, then it would mean that the green belt policy doesn't provide a clear reason to refuse development. So therefore, you wouldn't fall foul of this, and then you go on to apply the tilted balance. In reality, if the inspectors concluded very special circumstances apply, they're going to proceed to grant permission, and the rest of it sort of becomes a little bit academic in reality. Luke, have any measures been proposed to require a local plan review to come forward in a timely manner to address any shortfall under paragraph 227, where a local plan has already been submitted for examination with annual requirement 200 dwellings less than the published figure? There is a suggestion in the transitional arrangements. How this is enforced, I'm not entirely sure on, but there is a suggestion that if you have 227 applies, it's simply said that you've got to commence plan making in the new plan making system at the earliest opportunity. There's no mechanism there to enforce that. But as I said, the Secretary of State did indicate in the written ministerial statement that they'll take a more interventionist route. Now, that's been threatened in the past, and it hasn't particularly resulted in a huge amount of intervention. Whether we see that change, we'll just have to wait and see. Thanks for the question, though. Luke asks, how will live appeals being heard before the new NPPF is adopted be expected to deal with the draft NPPF and ministerial statement? Well, I'm in the midst of an 11-week run of back-to-back inquiries. So I am dealing with that very point in all of those inquiries now, and all the inspectors want to hear submissions on the new NPPF, certainly. So we'll have to wait and see. Are there significant changes in respect to renewables? Good question, Phil. Actually, yeah, I skipped over that, which is remiss of me. There are changes in respect to renewables, not not huge changes, I should say. Say for wind. Let me find that section. 164 is where he dealt with that. I'm not sure how I skipped over this, but there we go. There are changes in respect to renewables, giving significant weight to the proposal's contribution to renewable energy generation and a net zero future. So this, in reality, it's not a particularly, whilst that puts it into policy, typically most decision makers would have been giving significant weight to renewable schemes anyway, but that entrenches it into policy. And you can see that the exceptions or the restrictions in respect to wind have been removed. And I believe it was David Cameron government brought in restrictions in respect to wind, which have now been removed. Yes, a good question. Thanks for that. My view on the proposal to modernise planning committees. Well, certainly, Billy, it's not a feature of the new NPPF, so it's probably outside the remit of the talk for today, but thanks for the question. Do you think Pins will be writing to all parties seeking views on the impact of all outstanding appeals, given what you say? It's arguable that they ought to. I can't really get into it more than that because it touches upon a live appeal I'm involved in, that particular question. But yeah, good question, Paul. Right, folks. Well, it's just coming up to 1 o'clock. So I think that's probably where I'll draw stumps there. Thank you, as indicated, thank you so much, folks, for joining. Hopefully some of you got something out of that. I certainly did. Thanks for all the questions. Really, sincerely, it does mean so much that so many of you would have joined. This will be made live and it will go on YouTube if you want to watch it back again. And as I indicated, thank you so much for joining me. Have a wonderful week. Thank you all.